When Warner Brothers tried to use California's anti-SLAPP law to dismiss a lawsuit brought by Michael Crichton's estate, claiming Warner's new medical drama, The Pitt, was an unauthorized derivative of ER, the court said no. Now, Warner Brothers is fighting back. In a detailed appellate brief, the studio argues that the trial court misapplied the law and failed to hold the Crichton estate to its burden of proof. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner and frequent briefing contributor, Tara Sattler. We are going to talk about Warner Brothers' appeal and what it could mean for anti-SLAPP motions in the entertainment industry and dealing with entertainment disputes on today's installment of The Briefing. Tara, welcome back to The Briefing.
I'm back. Thanks for having me again, Scott.
Absolutely, absolutely. So I know you like The Pit. I like The Pit. I think this is great. It's one of our, I think it's a great show. Um, but it's mired now in this dispute with Warner Brothers or with Michael Crichton's estate.
Yeah, it is. So let's talk about it. This will be an interesting one as it continues to unfold.
Yeah. Okay. So to understand Warner Brothers' appeal, why don't we take a step back and let's revisit the story behind the lawsuit. It's a dispute that started with ER, which by all counts really was one of the most successful medical dramas in television history. And now centers on, at least the dispute centers on The Pit. That's a new series that Michael Crichton's estate says is essentially an ER reboot. Michael Crichton, of course, was, a prolific author, but he was also the creative force behind ER. In 1994, Crichton, Amblin Entertainment, and Warner Brothers Television entered into an agreement to produce the pilot and eventually the series, which ran for 15 seasons, wow, and became a cultural phenomenon and helped really launch the careers of George Clooney, Juliana Margulies, and Pitt star Noah Wyle. The 1994 agreement between Crichton Amblin and Warner Brothers contained what is referred to in this case as a freeze provision. And that clause stated that any and all sequels, remakes, spin-offs, and or other derivative works shall be frozen with mutual agreements between Crichton, Amblin, and Warner Brothers being necessary in order to move forward with any of these categories. I'm going to call attention to the word other derivative works because that plays a very large role in this dispute. Okay. After Crichton's passing, his widow, Sherry Crichton, through Roadrunner JMTC LLC, became the representative of his estate and the party responsible for protecting and enforcing his contractual rights under that 1994 deal.
Okay, great recap. So now let's fast forward to late 2022. And according to the complaint, around Thanksgiving of that year, Sherry Crichton received a call from ER's original showrunner, John Wells. He told her there was about to be a big announcement on Deadline that an ER reboot starring Noah Wyle was going to be produced by Wells and Warner Brothers Television for HBO Max. Then negotiations followed. Warner Brothers made an offer, the estate countered, and the estate's counteroffer included a guaranteed created by credit for Michael Crichton. But according to the complaint, Warner Brothers said there would be no improvements to its offer. It was a take it or leave it. So Sherry Crichton declined and withheld permission for the project to move forward.
So not long after that, Noah Wyle personally reached out to Sherry Crichton, apparently trying to keep the peace and keep the project alive. The complaint quotes from Sherry's email to Wiley, which said in part, the idea of you returning to your signature role as Carter with John Wells as showrunner is exciting and filled with tremendous potential. But ultimately, all this rests with Warner Brothers. If Warner Brothers wants to re-engage a fair and appropriate negotiation for a series as successful as ER and treat us respectfully through the process. My representatives stand ready to talk. Over the following weeks, discussions continued between Wells, Noah Wiley, and Sherry Crichton. According to the complaint, they even reached terms acceptable to Sherry Crichton, which included a commitment to support a created by credit for Michael Crichton before the Writers Guild of America and a $5 million guarantee if that credit wasn't granted. But when Warner Brothers stepped back into the negotiations, things changed. The estate says that those key terms were dropped, or maybe not approved by Warner Brothers in the first place. I guess we'll find out at some point in time. And Warner Brothers declared the ER reboot dead. Flatline.
Right. Uh, Except, according to the complaint, it wasn't really dead. Within weeks, Warner Brothers announced The Pitt, a new medical drama with the same producers, the same lead actor, and airing on the same platform. The only real difference, the show was set in Pittsburgh, not Chicago. In a statement, the Crichton estate claimed that changing the name and setting didn't change the fact that The Pitt was essentially ER reborn. Same premise, same theme, same place, same star, same creative team. Warner Brothers, for its part, called the lawsuit baseless, insisting The Pitt was a new and original show.
The estate sued in Los Angeles Superior Court in August 2024, asserting three causes of action: breach of contract, alleging that Warner Brothers violated the 1994 freeze provision by making The Pitt without consent, breach of the implied covenant of good faith and fair dealing, and intentional interference with contract against the other defendants, including Wells, Noah Wiley, and another producer, R. Scott Gamel. Warner Brothers responded with an anti-SLAPP motion, arguing that producing The Pitt was protected speech under California Code of Civil Procedure Section 425.16, and that the estate's claims were an improper attempt to stifle creative expression.
So, when Warner Brothers filed its anti-SLAPP motion, the studio argued that this case was exactly what California's anti-SLAPP law was designed to stop: a lawsuit that targets speech activity protected by the First Amendment. In this case, the creation of a television show.
Right. Under California's anti-SLAPP statute, the analysis really happens in two steps. First, the defendant has to show that the lawsuit arises from activity protected by the right of free speech or petition. And then, second, the burden will shift to the plaintiff, and they have to then show a probability of prevailing on their claims. And that means presenting admissible evidence, not just allegations or inferences. So it's a pretty, it's a pretty big burden to for the plaintiff to meet. They essentially have to prove their case in an anti-SLAPP motion.
Yeah, yeah, you're right. So the trial court agreed with Warner Brothers on that first step. The judge found that producing The Pitt qualifies as protected speech.
But as for the second prong, the court found that Crichton had submitted enough evidence to meet the minimal merit standards to show that a prima facie case that The Pitt was derived from ER, or said in another way, a derivative work of ER, and that Warner Brothers could have violated their prior contractual obligations, namely that freeze provision. So, okay, let's talk about really what's at the heart of this case. And that really is what exactly is a derivative work. And that was at the heart of the trial court's ruling in its denial of the anti-SLAPP motion, and it's at the heart of Warner Brothers' appeal. What exactly is a derivative work? That phrase is key because, as I noted previously, it appears in the 1994 ER agreement, that clause that froze all of the sequels, remakes, spin-offs, or other derivative works of ER unless Crichton, Amblin, and Warner Brothers all agree to move forward. The Crichton estate says that The Pitt falls squarely within that prohibition, and Warner Brothers says that it doesn't even come close.
When Warner Brothers filed its anti-SLAPP motion, it took the position that the term derivative work should carry the same meaning as it has under copyright law. That's a defined term in Section 101 of the Copyright Act, and it's defined as a work based upon one or more pre-existing works, which recasts, transforms, or adapts the original. Courts have interpreted that to require actual copying of protectable expression, not just shared ideas or similar themes.
Right. One of the ways I like to think of derivative works, a derivative work would otherwise be a copyright infringement absent the consent of the copyright owner to create that derivative work. Okay. So, under that standard, two medical dramas about emergency room doctors don't become derivative works of each other just because they share a setting or a tone. And you and I talked about this previously in our previous episode where we covered the trial court's denial of Warner Brothers' anti-SLAPP motion. Warner Brothers pointed to cases like Barrick versus Crichton, ironically, involving Michael Crichton himself, where the Ninth Circuit said that general plot ideas like crime and corruption or the hero saves the day aren't protectable. Warner's position is that the Pitt borrows nothing from ER that's protectable under copyright law. Different characters, different stories, different structures of the series itself, even a different city. The only overlap, they say, is the broad idea of a medical drama and the presence of Noah Wyle, who plays a completely different character.
So the Crichton estate, on the other hand, argued in opposing the anti-SLAPP motion that the 1994 freeze provision in the ER agreement wasn't meant to use the Copyright Act's definition of a derivative work at all. Instead, they said that the parties intended the term to be understood in its plain, ordinary sense, essentially meaning any work that develops from, grows out of, or is inspired by ER. Their evidence for that came primarily from a declaration by Stephen Katz, the attorney who negotiated the 1994 agreement on Crichton's behalf. Katz stated that when he and Crichton used the phrase derivative works, they understood it to include any work related to or based on ER in any way, not just one that copied specific creative expression.
Now, Warner Brothers challenged that declaration at the lower court, arguing that Katz's statements were inadmissible extrinsic evidence because they reflected only his subjective, uncommunicated intent. Warner's position was that Katz never said he was communicating that ordinary meaning to Warner Brothers during negotiation. So Warner Brothers said his declaration should be disregarded entirely.
But the trial court didn't see it that way. The judge acknowledged Warner's evidentiary objections, but ultimately held that Katz's declaration was admissible for a limited purpose to show that an ambiguity might exist on how the phrase derivative works was used in that 1994 ER agreement. In other words, the court found that Katz's statements, even if subjective, were enough to raise a triable issue about whether the parties meant derivative works in its plain English sense or in the copyright law definition sense.
Yeah, exactly. And that's critical. Once the court found that there was an arguable ambiguity, it concluded that the Crichton estate had shown the required minimal merit to survive the anti-SLAPP motion. The judge reasoned that if derivative work, the term derivative work in the 1994 agreement could reasonably mean any project derived from ER's concept or universe, then the Pitt might qualify. And by the way, so could like almost any medical drama qualify, especially given the overlap in the creative team cast and premise.
Yeah, so that's a big difference. Under Katz's interpretation, the estate doesn't have to prove the Pitt copied scripts, characters, or scenes. It just has to prove that it was conceived as a continuation or offshoot of ER.
So, like, I guess the question is, should the court have applied, the trial court have applied the established copyright law meaning of derivative work here? There were sophisticated lawyers on each side. The deal was related to a work that goes to the heart of the Copyright Act. And Crichton's lawyer didn't say that his side was interpreting the term derivative work differently than the standard copyright definition. And by the way, I might add probably the the way in which probably most lawyers doing a deal that includes the phrase derivative work would interpret that term.
Yeah, that's a good point, Scott. As lawyers, when drafting an agreement where a work covered by the Copyright Act is central, we should be able to use terms that have a generally understood meaning. I mean, if that was the case, do we have to define every single term used? Do we need to define what it means to infringe a third party's rights? We could go on and on like that. So, on appeal, Warner Brothers argues that where words have a definitive legal meaning, we presume the parties intended to have their ordinary legal meaning, unless a contrary intent appears in the instrument. This is the standard the district court should have applied.
Fundamentally, 100% I agree with you. However, let me play devil's advocate here. In a quick review of some past deals in our that we've done, our firm has done, I do note that in the work made for hire section, most of the agreements say that whatever it is that's being created is a quote work for hire or work made for hire as defined in the United States Copyright Act. So, how hard would it have been for the parties to have done the same here? To say, or other derivative work as that term is defined in the United States Copyright Act?
Yes, that's true that often or most of the time the Copyright Act is referenced in the work for hire provision, but that isn't the case every time, and it shouldn't have to be. Work for hire and derivative works are defined in the Copyright Act. Those definitions are well known and frequently used in the media and entertainment industry, and there shouldn't have to be a worry about a game of gotcha in drafting. If you don't specifically say that either word is to be defined pursuant to the Copyright Act, then the other side could slip in some uncommon definition that wasn't conveyed at the time.
Yes, I fully agree with you. This ruling allows for ambiguity in drafting, which transactional lawyers absolutely hate. The result will be longer agreements, longer definition sections, and more time and expense to the clients drafting these agreements. So, okay, so what's at stake here? If the Court of Appeals sides with Warner Brothers, the case could be dismissed entirely under California's anti-SLAPP laws. That would end the Crichton Estates claim and send a strong message about the limits of the frozen rights clause or other similar clauses in old studio contracts.
That's right. And if the appeal fails, the estate will get to move forward with discovery, and Warner Brothers would have to defend the Pitt project and come up with a lot of information and emails and scripts and drafts and testimony that would be very burdensome.
Yeah.
And I also think that would set a pretty difficult precedent for content creation in general.
Yeah, I think the trial court's ruling is problematic. I think that look, I understand there's supposed to be a meeting of the minds, right? And if there isn't a meeting of the minds, then essentially you you don't have a contract on that certain provision of the agreement. And then the court is allowed to determine like what was the party's intent. But there should be any ambiguity when you're using a term that, as you noted, is well defined, is defined in the Copyright Act, is a term that is used frequently in the industry, that is a term that is used frequently by both of the lawyers on both of the sides of the deal. I think, and especially to allow one attorney to say, well, I understand that it has this ordinary meaning, but I meant something else. Oh, but I didn't tell the other side about it. And I probably knew that they intended the ordinary meaning, but I still didn't tell them anything about it. I just think that it will raise some very problematic issues when it comes to contract drafting. And it could open up it can open up just a big can of worms on contractual interpretation or interpretation of terms where people are relying on like common meanings or industry standard terms uh, and try to get around what would be a common interpretation. I don't know. I didn't like the district court's ruling or the trial court's ruling when it was made, and I still don't like it.
I definitely agree with you, Scott, and I think that adopting what the Crichton estate is saying would really open up a can of worms and create a really big problem for the film and television and media industry as a whole. Because with that broad of a definition, so many different shows could make claims against the others just because they happen to come first in time. And that is a huge problem and burden for production companies and studios to have to manage. It just to me is not logical in the way that our industry actually functions.
Yeah. Let's flip it the other way, right? Let's think about it in the terms of a rights deal, right? We've got a rights deal where we've got a studio that has it's acquiring a rights in a book to make a television series or a motion picture, and it has the right of first refusal on any derivative works. Uh, and if it just says like derivative works, right, a studio could start to take a position that, oh no, like we didn't mean like, a like a sequel or a prequel to this particular book with this particular character. We meant like, anything that's a murder mystery that you write, right?
Any
Because
love story.
yeah, right. Any love story that features a heroine and a hero.
Yeah.
It's yeah. I mean, you could. It's the camel's nose here, and I don't. As I said before, I didn't like this case. I didn't like the court's ruling when they made it, denying Warner Brothers' anti-SLAPP motion, and I continue to not like it. But we're going to keep watching this appeal closely because whatever the Court of Appeals decides will, as we have just kind of ranted here, have some real implications for studios, creators, and production companies in negotiating like all types of deals.
And us for lawyers and drafting them.
Yeah, right. So clients, if this case, if the Court of Appeals doesn't get rid of this case, then expect longer agreements with even longer defined terms section. Thank you, Tara, for joining me today. Always great to have your insights. And thank you to our listeners for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review, or feel free to rant with us about this opinion, and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey, and I'll see you next time on The Briefing.